Well, okay. Here we go. The infamous 58-page letter from Sarah Boone to Judge Cranick, which was she promised him and hand delivered to him in their last meeting back was it when did they meet last? What day was that? June, a couple of days ago. Last time she was in court. I'm trying to see what it was here. My notes. Anyway, this is it. Now look, guys, we've all been through her letters before. We know that it's repetitive. We half of us want to vomit, half of us can't stop laughing, and half of us can't even stand it. So just bear with me. We're going to take this one page at a time. I'm going to read this. I'm going to try not to throw up while I'm doing it. So just here we go. Oh my God. She's starting with bullet points. Good Lord in heaven. All right. Mm-mm-mm. So as you can see, she's got ongoing 5 years. Why can't I dot dot dot? And here are her bullet points. They need to get this woman a PowerPoint. Get her access to a PowerPoint presentation. Use my constitutional rights. Am I the only one who cares about the ongoing violation of ongoing violations? I don't know what that is. Why can't I have a bond? Why can't I have all my medical records? Why can't did they gave her? I thought they gave them to her. Why can't I have all my digital evidence and discovery? Why can't I have all my paperwork, notes, letters, pictures, everything of mine returned by former attorney? Why can't I speak to my investigator? She keeps asking that one. Is there an investigator, guys? Is I'm confused about that because you would have to pay for that. Why can't I have a complete download of my phone? Why can't I have any of my witness list? Well, you know what, Sarah? If you end up uh, representing yourself, honey, you're going to get all this and more. They're going to come in there with all this discovery material for her, and it's gonna be like 20 boxes worth of stuff. And then she's going to write a letter complaining that it's too much. Okay. Why can't I have any of my witness lists? Why can't I give any insight, understanding, clarification, truths about my case, especially in my to my attorney? Why can't I be listened to by anyone, especially my attorney? Why can't I be respected for who I am truly, especially by my attorney, and not be disrespected for the mutated, that's right, she likes that mutated word, mutated, malicious murder all the world has falsely incorrectly created and believes me to be. Why can I be treated fairly, lawfully, and be protected by the justice system? Why can I properly, rightfully, completely defend myself? Oh, you're going to be given the opportunity. It seems like it. Why can't I see all and know the same as the world can and does, including my attorney, from all the phenomenal, non-permissive amount of at my entire case being available online globally before my trial, and most important, before I've seen it myself. Why doesn't anyone know already about my case? How about my side and everything about everything? Well, Sarah, if you would cooperate with your attorneys, then eventually you'll go to court, and then that's where all that comes out, honey. Why can I be correctly understood that I'm not the problem? For reasons I am on. What is that? For reasons I am on something something appointed by the court attorney number 8. See my letter dated 7/21/23. Why can't I say what I want and should, but all the world can and say it all wrong and warped? This woman doesn't need a trial. She needs a freaking therapist. Okay, really quickly, I just had a thought while I was looking at this. At the same time that this was uploaded to Orange County's docket, this was done Friday. Was it done Friday? The hearing dates for September have not changed. So this letter hasn't changed anything. And I think poor Patricia is stuck with Sarah. Her eighth attorney is going to be who she's stuck with, or if there's not going to be another attorney brought in, I mean, maybe he's saving the date to go back to Sarah to go, you know what, Sarah? It's all yours. Take it, girl. Go with it. Peace be with you. May the force be with you. Oh, now. Okay, now we move on to another PowerPoint slide where she says, why won't my attorney ... give me an answer, an honest answer? Why won't my attorney show me everything she says she has and finished reviewing for my case, but withholds from me after I have asked repeatedly for and about? And you know what? I think there's one thing, if Sarah's being truthful about anything in this letter, her asking repeatedly is probably the truth. Why won't my attorney give me an answer other than I'm putting this to rest? That's not necessary, or I'm not having this conversation with you. Why won't my attorney grant me access to anything I ask her for and in and about my case? Why won't my attorney, like the detectives in my case, stop putting words in my mouth? So she's saying it's just like the detective. Y'all need to stop putting words in my mouth. It was not intentional. Why can't my attorney tell me what's going on in my case? It's been well over 100 days. She has been my attorney, and I still do not know ongoing 5 years. I don't know what she means there. Why can't I answer any of my questions? Why can't my attorney answer any of my questions? Because you have too damn many of them, Sarah. Shut the F up, Sarah. Why can't my attorney ever ask me about any questions? Because she doesn't want to listen to you go on and on and on. How can she supposedly know everything she needs to know from what she's been told, heard, read, seen, reassure she's on something side? For me, not against. For on my side, not against. Sarah, we're all against you at this point, honey. You've made the world hate you. Why can't my attorney have I already been judged in the court of public opinion? How did that happen? Why have I been oh, now she's switching up her PowerPoints. Why have I been sentenced by anticipation and condemned before my predicted trial? Because you can't keep your freaking mouth shut. Why does my attorney and all the world think my case is already over? Because you recorded it, you idiot. Your Honor, during our first introduction at my last withdrawal of court appointed attorney number 7, which was Hobson, you stated to me your uninvolvement with any of my letters I write. I am still going to write this letter. As conduitely they are to the world where all my potential jurors and located what? As conduitely they are to the world where all my potential jurors are located. And this is the only way anyone, including yourself, knows to very necessary insight to my continued disadvantages. Oh, so she wants her upcoming jurors to read this letter. Hindrances, impediments I am still experiencing on top at the news spurring something intentions to write. Oh, God. I swear, looking at her handwriting sometimes, I go in and my eyes get crossed. The race to the pulpit is unfair, and it is important to me that you are aware and understand what transpires when the news cameras are off and we are all in between my status hearings. So she's basically saying Judge is putting on a show for the cameras. Not good. Why do these people lash out at the judges knowing that they're going to, or do they not realize the judges most of the time make the final call as far as how long they're going to be in jail. Two, as so many of the advantage, mm, two, as so many of the advantageous embezzlers, racketeers, mindless lemmings, and just altogether near people can use their freedom of speech, not knowing me in any way other than what's being said by all the other mean people and being said incredibly incorrectly. So can I. So can I. You know what she needs to do? She needs to take all this energy and write a book. That's what she needs to do. Of course, this is 58 pages. I guess this is a book. As to the compelling, annoyed detectives in my case, the detective had to fairly falsely falsify documents, and Lowen wore his gun for me to see. I am sure you are familiar with after watching all of my plastered, high, misconstrued, over 30 plus million viewed just on one site interviews. So so Sarah's on YouTube, and in which they both repeatedly attempted to feed me their incorrect, incomplete, hypothesized opinion by stating to me everyone has their limits at this seemingly endless point of perpetuality of nonsense and lawlessness still growing, and I very much want to advance to the next level after ongoing 5 years now. Is this really page 4 to 5? I guess. Okay. At least she's got the sense to start numbering her pages since she has so many of them. A genuinely concerned limit has been reached. Why am I still not included in my case? How much more of my case and self is being added hourly, especially after the letters get loose? Well, why are you writing them if you know they get loose? They get loose to the internet, increasing the mass infection and destruction of my hopes to have a fair trial, anything fair, my side foremost, and wondering now if my attorney drank the punch like everyone else. Oh, okay. It's Jonestown now. It's Sarahtown. After all aforementioned reasons, and so many more, for this letter to be written, hopefully to deter some of the unfair, one sided anger pointing, something corruption and malpractice being directed at me only by those in the justice system who are trying to deflect the something and shock from me, fearlessly challenging the status quo. And it must be so because it's in my face on the computer at the same time on my boob tube television. What? Brainwashed, ignorant, allowers of disbelief, conformity, and greed, trying unsuccessfully to make my life by character assassination seem worse than theirs. No, two, when anyone points their finger, one, it's impolite, and two, three point back at you. How many tried to see it? Tried it to see. How many tried it to see? Put the stone down, as there will be no casting of anything today, except maybe for the role of my part for all of the conclusioned documentaries and crystal ball real life something of true crime. Stories of true crime, incorrectly formulated from everyone supposedly knowing me and judging me, who they think I am, what really happened, and is going to futuristically. Remember, 3 point back, soothsaying is not a real job. I don't know about y'all, but right now I'm just feeling so attacked by Sarah. To sum it up, the words of my attorney after I told her to Google me, she states, there's a lot. To sum it up in the words of myself, the defendant stated to my attorney after she stated that to me, when I can see, how much longer do I have to wait? Or how many attorneys must be withdrawn for me to be included in my case and be included more than the world presently is. So, okay, so let's just break this down because we've just got through this page 6. So Sarah is basically saying that we, the world, know more about her case than she does. We don't, Sarah. We haven't seen all the files. Not yet. We're waiting for trial just like you are. And then we'll condemn you. This is my case in every aspect. See all my aforementioned ongoing 5-year questions I am still waiting on for answers. Page 7. Also, I want to make it known I walked out on my attorney in our last meeting due to her unwarranted, uninformative, unprofessional, snotty attitude and her untruthful answer to my questions and beyond. Retarded vicious circle we enter every time we meet is a waste of time, and I'm saying that in jail with supposed endless amounts of time. How she treats me is extremely prejudiced, hostile, and unconcerned. I don't think she proofreads these. I really don't. She should maybe see if one of her cellmates will proofread for her. She is very frustrating. 1, to balk or defeat in any endeavor. 2, to induce feelings of insecurity, discouragement, or dissatisfaction. Or 3, bring to nothing. It doesn't make sense what she's saying. Basically, that's saying exactly what they were saying on court TV, is that these attorneys are telling her, this is what's up. This is what's going to happen, Sarah. And she just doesn't want to believe it. So because of that, she feels like they're being disrespectful. I mean, does she want to be patted on the back and go, Sarah, we're going to get out of this. And you know what? You're going to go free one day. You want to be lied? She wants to be lied to. So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, and appropriate manner. I added pretend judge to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. She seems like everyone else, not to remember I am innocent until adjudged otherwise. She treats me as if I am not. She's coming in with the real life stuff to you, and you don't want to hear it, Sarah. Page 8. After my introduction and explanation for with pretend judge in the room or on the phone, I'm trying to help her understand how she is making herself extremely unwelcoming. When in front of a real judge and in the courtroom is how she should treat me, her client, at all times. I should not have to invent pretend judge in order to be, and am not at all wrong for wanting to be respected, no matter the outcome. I am innocent until adjudged otherwise. My attorney, everyone's, should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. I should feel secure, highly confident, proud in her representing my life. I do not, and have said to her many times regarding how oh, monumental disbelief in me and my case, which I believe contributes greatly to her something attitude, inimical, attitude towards me. I'm hoping by this letter she will pick up the word of the sword of justice. Oh wait, I'm hoping by this letter she will pick up the sword of injustice and fight alongside, not against me, and so many unmotivated, overwhelmed, weak attorneys prior who bowed out ungracefully and crept away from the battlefield unsuccessfully. Oh, she's so dramatic. Page 9. My case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, equals unfair. This does not mean my case can't, excuse me, can't equal success, and in many ways, and in more ways than one. While everyone continues to ring their bells of malevolence, I am ringing mine of hope, honor, plausibility, boldness, period. Listen, period. I am not a murderer. The justice system should equal fair, faith, truth, trust, respect, innocence until and if adjudged otherwise. 3 point blank. 3 point. I would think that would be 3 point blank, but 3 point balk. I don't know. Back 3 point back. I don't know. Sarah Boone, and again she leaves us a little heart emoji. Confused cat meme. Oh, Lord have mercy. Yes, period. Thank you, period. Oh, Lord have mercy. Okay, that was, no, I don't, what is this? One. Okay, so oh, we're going to break down here all of her visits with her attorney, I guess. So this is page one, June 4th of 2024, video visit, 12 minutes. In addition to my previous letter intended for hand delivery on June 7th, 2024, at my status hearing today, my attorney made a video visit to go over everything. I've been asked for her for and have also sent to her personally in two letters, 520 and 525, all on the public videos visitation box, where on both sides of me, less than 5 inches away from my visit, other inmates were having their visits also. Okay. I've explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having in-depth private meetings regarding my entire criminal case on the visitation box where there is no privacy whatsoever and held in an open bay dorm with more than 62 other interested all ears inmates. Oh yeah, it's all about you, Sarah. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. As always, my attorney did not listen or care after I repeatedly tried to remind her of my page two unsecure environment backing at me. Wait, page two equals page 12. Okay. Unsecure environment barking at me. I can listen or not, still going over, speaking, and not at all allowing me to respond. After repeating to her over and over and over, while she's beginning to speak louder and over me still to please schedule an in person meeting where all can be discussed further, privately, with no success of being heard, I disconnected the visit telephonically. She is impossible. See previous letter or ask for her for a copy of the two I sent her. Oh, yes, please let us see those. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include you. Now it's a race to the pulpit. My question, please, who acts like that and still be able to call themselves professional? The visitation box is primarily for family and friends to connect. And if a must from an attorney, reminders, notices, quick questions, not high level confidential case information. She, like other former attorneys who always, always, always blame their dysfunctions on me, said, "You don't like the answers I give you." What answers? Sarah said. See page 1, 2, and 3. Um, and now we're on page 3. I am not the problem, except that I want and I should be treated fairly. Okay, now notice here she's gone into all caps, so she's getting highly agitated. Just wanted to point that out. With respect, acting more professional than the paid. I've been doing this forever. Wait, I've been doing this for over, she put 40 years, but I think she meant for, oh, yeah, that's what the attorney said. I've been doing this for over 40 years, professional. After so long, And in all the experience, common courtesy, customer service. Oh, she wants customer service. Can I please see a manager? And listening skills should have been acquired. Y'all, that just made me think of something. Do you really think that, like, while Sarah's talking to her attorney, she's like, I want to talk to your boss. Who leads your firm? I want to talk to the owner of the firm. All attorneys, do you remember why you even wanted to be one? Remind yourself. Oh, she kind of sounds like Letitia Stout there. No one listens, and it works in everyone's favor but mine, that I am a murderer, stuck in jail so they can pin on me. They're uninterested, unmotivated, hopeless. They're going to leave me over her haughty attitude. And if y'all are just listening and not looking at the screen, please know I'm just reading what's in front of me. I'm not saying it makes sense. It's written by Sarah, okay? I'm not wrong for not thinking less of myself because everyone else has and does, this present attorney foremost. The justice system expects me and other inmates, aka clients, to accept its something bar, nonchalant, subpar. I think she meant subpar. Nonchalant, hypocritical, next on the list attorneys they keep aimlessly throwing darts for and malappointing, praying they don't withdraw. Page 4. Okay, big caps, couple of underlines here. I have not fired any attorneys appointed in my case. From me, expecting the highest equal standards possible for wanting the absolute best outcome in my preposterous, mismanaged case. And representing myself is not an option. Oh, really? Okay, let's listen to this. And representing myself is not an option, as both judges have now threatened me with from being outspoken and intelligent in all observation of the ongoing abuse. I am and I have experienced. I have no experiences from it always being the same. Blame Boone. Aw, we should get her a t-shirt that says that. Blame Boone. And then on the back it could say, Suitcase Sarah. I refuse to be moved in wanting respect, no matter who everyone thinks I am. Clarity, conclusion, honesty, and professionalism. And another great reason not to have my case meetings on the public visitation box is my personal confidential inmate information, such as my visitation list with names, etc., my interactions with inmates and officers. Page 5. What I eat, when, and my personal jail calls also being thrown online for what? To hate me more or to try to get others to because I don't eat breakfast or because I know some Latin, have short hair, my penmanship is nice. I disagree with that one. Or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate, narrate, splice, edit. The world apparently knows all. Once again, she's saying out loud that she's better than everyone else. And she excels at everything she does. What's next? How many times I go to the bathroom and what function I perform? Yeah, well, you could keep that. We don't need that, Sarah. No one knows anything, nor seems to want to from being comfortable in their corruption and sitting to be on top with ratings, web hits, and money. My case details, if anyone forgot, and if you think about it, all that keeps getting plastered and plagiarized, posted and poked. Something fun at about me. It's all in my favor, proving myself right about all mindless lemmings, shut-ins the justice system advantageous, abusing, and profiting from everything in my case before my trial and before I've seen. Please be sure to read my attachment for something rule. It's a thing. Restricting disclosure. Am I the only one who thinks of these things? Now we're on page 6, which is actually page 16. When can I win? In anything. It's coming. I am not the problem. And if anyone were to slip on my slides and have to experience, tolerate, deal with any of what I have and am, would bravely be doing the same. Don't knock it till you try it. 3-point back again. What is that? I don't know what 3-point. I've never heard that expression. Race to the pulpit. Again, always Sarah Boone. Okay. Now, if she just wrote out some statutes here and that's all this is, we're not reading it. Page 17 says West Florida statutes annotated. Florida rules of criminal procedure. And that's exactly what she's done. She's written these out. 2, 3. Oh, let's see. She highlighted H. Whether there has been any electronic surveillance, including wiretapping, of the premises of the defendant or of the conversations to which the defendant was a party, and any documents relating thereto. 4, 5. Defendant's obligation. If a defendant elects to participate in discovery either through filing the appropriate notice or by participating in any discovery process, including the taking of a discovery deposition, the following disclosures shall be made. Within 15 days after receipt by the defendant, all the discovery exhibit furnished by the prosecutor pursuant to subdivision blah 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 of this rule, the defendant shall furnish to the prosecution a written list of the names and addresses of all witnesses whom the defendant expects to call as a witness at the trial or hearing. And it just goes on and on. So she's like, this is what's not being done, I guess. Again, I'm not going to read these. That stops at page 10. So there's almost 10 pages of that. And that now we're on page 27. Okay, I'm sorry, but for some reason, this page is not numbered, or it was cut off when it was scanned, and it just picks up in the middle of anywhere. But she's still writing the laws. Okay, now oh, Lord have mercy. She has written the American Declaration of Independence, written in 1776. I can imagine her standing up there with her dang Pledge of Allegiance, got her hand on her heart while she's writing all this. So page 28, and then she writes down the Florida Constitution 2024. We the people of the state of Florida be grateful to Almighty God for our Constitution, liberty, in order to secure its benefits, perfect our government. What is she trying to do? I just don't understand. Okay, now we start over with another number 1. So I don't know what this is. These are basically just Sarah's notes, I think, at this point. Which this document we're on page 29 now. And she writes the definition of a client. Then she writes down attorney-client privilege. Then she defines zealous advocacy. Then on page 3 of this, she defines attorney misconduct. Page 4. Then she defines duress. Then she defines habeas corpus. Then she defines informal consent. Then she defines legal ethics. Then she defines equal protection of the law, page 36. Then she defines abuse of process. So she feels like all this is happening to her, I guess. Page 38. And she defines interrogation, examination of a suspect, custodial interrogation, excited utterance. Okay, now we have. Okay, this is interesting. On this page is the map of the United States. And it says publicity, exploitation, and saturation. Oh, wait. She's even included North and South America. Oh, she got the whole world on here. She included the whole world. Publicity, exploitation, and saturation. United States, on page 1, to date, each star is a state where I have received correspondence via mail or message regarding my current criminal case. Oh, now this is exciting. Hang on a minute, y'all. Page 2, or world map page 2. To date, each star is a continent where I have received correspondence via mail or message regarding my criminal case. And the number grows daily. Most all letter messages are available for review and understanding of the impact of my case details being made readily available on the global internet created wrongfully ignorance, hate, and massive prejudgment before my trial. I, the defendant in my case, have not yet ongoing 5 years fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. No, we haven't. The difference is, Sarah, most people don't record their crimes like you did. The continuation of the obvious exploitation allows the world to keep pressing their incorrect, presumed unfair theories, ideas, accusations, forcibly insinuating I committed criminal acts. Well, come on now, Sarah. If you watch my channel, in all fairness, honey, I mean, I didn't say that you were this, mastermind. I said you were just stupid and did something stupid, and it resulted in this man losing his life. So let's just make the record correct there, okay? All right, back to the letter. My present attorney said it is not necessary to receive a court order I've been trying to obtain to download my case information to apply from the OCCD tablets. My former attorneys are withholding some of my case contents I have supplied to them and which have been deemed lost. Many other items have been returned, not to myself, but to the next attorney, which have been unable to locate to date. I am missing innumerable case items which I continuously request to be returned or obtained without success. Page 44. Invasion of privacy, Supreme Court, wrongful conduct. And here she wants to offer more definitions of these different words. And I'm going to read the words that she's defining. I'm not going to read the definitions to each. This is like a freaking glossary. Okay. Appropriation, intrusion, public disclosure of private facts, false light in the public eye, defame, invasion of privacy, false light. Okay. And now she goes back to writing her thoughts. And we're on page 46. My personal, individual criminal case is being advantageously exploited and abused from all my significant life-saving, suppressible case details, evidence, proof being illegally obtained by coercion, trickery, duress, confusion, and without my permission in any form, written or verbal, to anyone, that broadcasted, distributed, hand delivered to the entire planet, states, countries, continents, containing all of my potential jurors, causing irreparable, erroneous falseness, greatly tainting my jury pool altogether by forcibly attributing heavily influenced, incorrect, inappropriate motives, theories, and ideas. God, somebody needs to teach this one word. Add a period. Okay. This obvious exploitation and invasion of my privacy is creating unnecessary, unlawful oppression, depleting all of my something depleting all of my. Can y'all tell what word that is? Entitled opportunities to be given a fair, proper, successful conclusion of my case. Not everybody gets a successful conclusion, at least not in their own, not in your eyes. She's really not. I mean, I don't know why she keeps saying successful conclusion. A misprejudgment has already been made unfairly against me from the undeniable violation of my constitutional rights and due process of law as a result of my entire case and personal life being publicized globally before my rightful trial, which lawfully, ethically should be without disadvantage and free from all partials, deceitfulness, I can't, partiality, deceitfulness, and dishonesty made from said evident exploitation. Oh, okay. So here she's writing down her this is not like a thesis or something. We're on page 47 and she says definition all of my information, my definitions were collected from, and then she puts in here the Bouvier Law Library, Law Library, the Merriam-Webster's Dictionary, and Smart Communication Tablet. Oh, Lord have mercy. We're going into more definitions. Who does this? Who thinks that the judge wants to sit here and look at this? Who thinks that this isn't a slap in everyone's face who's trying to do their job in this case? Oh, good Lord. Maybe she's going for insanity plea. I don't know. Okay, so here's the definitions, or here's the words that she's defined. But again, I'm not reading the definition. I'm just reading the words. Exploit, exploitation, abuse, significant, suppress, illegal, coerce, trickery, confusion, broadcast, distribute, deliver, irreparable, erroneous, falseness, false. Yeah, it says falseness. Taint, force, influence, incorrect, inappropriate, motive, invade, privacy, oppression, deplete, entire, fair, proper, successfully, prejudgment, unfair, undeniable, violate, constitutional rights, liberty rights, privilege or positive rights, procedural right, due process, procedural due process, substantive due process, publicize, rightful, lawful, ethical, disadvantage, partiality, deceitful, dishonesty, evidence, coerce or coercion, Freedom of Information Act. That's the key one, Sarah. And that concludes it with she ends the letter at page 58 with the definition of Freedom of Information Act. Okay. Well, there you have it, folks. The Sarah Boone letter dated June 7th of 2024, hand-delivered in court to the Honorable Judge Michael Traynick. I'm sorry, I said that wrong. Kranick. So, what'll happen? I don't know. I don't see the judge looking at this and making any. I don't know. Can they make her? Can they make her defend herself if she can't find anybody? I'm gonna go watch some law stuff now because I'm just frustrated with this letter. Well, I'll call it here. Thank you all for being with me here today as I read this letter. How long have we been on? God, please tell me I was recording that. Yes, I was. Okay, good. Whew. Okay, it only took me 45 minutes. That's not too bad, huh? That's not that bad. Of course, you got to remember, there's a lot of stuff we didn't read. We will revisit more. I want to put out there, I want to talk about her husband's interrogation. We want to talk about her neighbor's, or not interrogation, but interview. I want to talk about her neighbor's interview. And there's also an interview of George's brother. I think it's just those three left that I want to talk about next. So stay tuned, and y'all have a blessed day. Thanks for watching, everyone. If you enjoyed this video, please do not forget Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.